started. And okay, so when we are going to be looking, so here, we are talking about collective investment scheme. Okay, now there's this one case law which they've given to begin with. So let's see what is the case law. We'll try and understand the case law, more correctly to see where it is, what is the expectation, and all of that. So in this case, what we are saying in this matter, SEBI has had observed that Rose Valley Real Estate and Construction Limited. So there is this company by which we'll know it as Rose Valley, was mobilizing fund under collective investment scheme. Okay, so there's this company Rose Valley was what was it doing? See, collective investment scheme, Matasha, it's like a mutual fund scheme where you mobilize money from the public, but objectives are different. Like, for a mutual fund, the objectives are different, and similarly for a collective investment scheme, the objectives are different. So here in this case, there is this company Rose Valley which was mobilizing funds under CIC without obtaining a certificate of registration as required under section 11AA of the Act. Okay, so here in this case, there's this company mobilizing funds, but this is all done without obtaining the certificate of registration under section 11AA of the Act. So they are predominantly doing this without getting the necessary approvals in place. Rose Valley in turn moved the High Court challenging the constitutional validity of the said Act. Okay, so they basically did what? They went to High Court saying that this particular act of the CIC, which is Collective Investment Scheme, they said this act is not correct, and they moved to High Court saying that this act is not correct, and hence there is no validity per se that this act should have in place. So Rose Valley in turn moved the High Court challenging the constitutional validity of the said act. The Calcutta High Court dismissed the said writ petition filed by Rose Valley challenging the constitutional validity of SEBI's power in regulating CIC. Okay, so what happened then when the matter went to Calcutta High Court? The Calcutta High Court in turn dismissed the said writ petition. Dismissed meaning they said this is not a correct writ petition filed by Rosemary challenging the constitutional validity of SEBI's power in regulating CIC. So when the matter went to the High Court said, listen, this is not possible. You can't come to me and challenge the regulatory power that a regulator. So SEBI is a regulator for CICs, right? So they said it's not possible that you can challenge SEBI. That's constitutionally incorrect, and that's how that particular application, the writ petition that was filed by Rose Valley, was quashed, was basically cancelled by the High Court. Dismissing the writ petition, the High Court observed that Section 11A of the Act is legal and that provisions provided in is valid. The High Court also slammed a fine of rupees 10 lakhs on Rose Valley. Okay, now this is something that you need to understand. See, in this particular lesson, Natasha, what they have done is the institute has not given questions; it has directly kind of given a brief of what it is. Okay, like they are basically expecting students to know the answer directly. They've not given questions per se in this. Okay, so in this case, just quickly make a note. Just write down. I'm giving you notes for this. Natasha, you have a pen and a paper. Okay, write down section 11A. You have a pen and a paper. 1 minute. Let me see this. 1 minute. Natasha, be there online. Natasha, there is this FAQ which has been given by SEBI. Okay, I am going to stop this presentation, take you through that. Let's quickly study that as well because that's something which is given by SEBI and that's very, very important. So I'm going to share my screen. I don't know if you can. Uh, Can you see this FAQ, which is on collective investment scheme, which is given by SEBI? Natasha, can you see that? Okay. So we are going to actually study from this particular FAQ first. How big is this? We will see, because this will basically, give us a clear picture in terms of the entire collective investment scheme. Okay. So first, let's begin with, and once this is done, then doing a presentation becomes a little more easier, because then from that perspective, we know that the base that's required to understand the entire the base that's required to understand the case laws is already done. Okay, so in terms of what is meant by collective investment scheme, we say collective investment scheme is any scheme or arrangement which satisfies the conditions which are so being stated in subsection 2 of section 11A of the SEBI Act. Okay, so there's this SEBI Act. There are certain conditions for a scheme to be, there are certain conditions that you will have to qualify in order to call that scheme as collective investment scheme, which is something which is given under section 11AA, subsection 2. Any scheme or arrangement made or offered by any company under which the contributions or payment made by the investors are pooled and utilized with a view to receive profits. Okay. So what are we understanding currently, Natasha? We are understanding that collective investment scheme is nothing but a scheme or an arrangement which is made or offered by way of a company under a contribution or payment made by the investor. That's what I told you there, right? This is more like a mutual fund thing, okay, and which are pooled and utilized with a view to receive profits, income, produce, or property, and it's managed on behalf of the investors, which is what is called as CIC. Investors do not have day-to-day control over the management and operation of such scheme or arrangement. Is that understood? That from an investor's perspective, they do not have the control over the management and operations of such scheme. Understood? Perfect. Okay. Now, what are which are these schemes not treated as CIC? Which are these schemes where we are not treating them as CIC? The following do not constitute a collective investment scheme. When we say the following do not constitute, the point really is what is not a CIC. Natasha, take a pen and a paper and write down. There are these 1, 2, 3, 4, 5, 8 points. Okay. So first you write down, this is very, very important that you need to understand, get your concepts clear, because until your concepts are clear, it will be very difficult for you to attempt and understand the case laws. Okay. So currently, please write down in terms of which are these schemes which are not to be treated as collective investment scheme. Now this is very important. Then while you understand what is collective investment scheme, it's always very important to understand what are exemptions. Okay. So quickly write down any scheme or arrangement. Matasha, you writing it down, right? Okay, write down any scheme or arrangement made or offered by a by a cooperative society, or a society being a society registered or deemed to be registered under any act relating to cooperative societies for the time being in force in any state. Point number 2, any scheme or arrangement under which deposits are accepted by non-banking financial companies. That's my point number 2. My point number 3 is any scheme or arrangement being a contract of insurance to which the Insurance Act applies Point number 4, any scheme or arrangement providing for any scheme, pension scheme, or the insurance scheme framed under the Employee Provident Fund and Miscellaneous Provision Act of 1952, any scheme or arrangement under which deposits are accepted under Section 58A of the Companies Act 1956, any scheme or arrangement under which deposits are accepted by a company declared as a nidhi or mutual benefit society under Section 620A of the Companies Act 1956, any scheme or arrangement falling within the meaning of chit businesses as defined in Clause D of Section 2 of the Chit Fund Act of 1982, any scheme or arrangement under which contributions are in the nature of subscription to a mutual fund. Now, these are certain things that we need to be mindful of as far as calling a scheme not to be treated as CIC. So, these are certain things that we need to be careful that, okay, so while we understand that CIC is nothing but a pool, where the pool of the money has been taken from people and they are to be utilized to receive profits, income, okay. So, at any given point in time, these are your certain exemptions. So when we talk about these particular points, we are saying that these are not to be treated as CIC. Very, very important. Okay. What is a collective investment management company? If you have any question, please feel free to ask. Otherwise, I'll continue assuming that you're understanding. Okay. So when we talk about collective investment management company, when we talk about it, so we say is a company which is incorporated under the provisions of the Companies Act, that's one, and which is registered with SEBI under SEBI Collective Investment Scheme Regulation 1999, and whose object is to organize, operate, and manage a collective investment scheme. This is what, when we talk about collective investment management company, this is what we predominantly understand, that collective investment management company is a company which is incorporated under the provisions of the Companies Act. This is something which is registered with SEBI under the SEBI Collective Investment Scheme Regulation 1999, and whose object is to organize, operate, and manage a collective investment scheme. So this is what we understand as far as what is a collective investment management company. What is an existing collective investment scheme? Entities which were operating as a collective investment scheme at the time of commencement of CIC regulation are deemed to be an existing. So which are these collective investment schemes? Something that was already in existing, and the new ones as well. So you don't have to worry too much about it. Can